Welcome to the Hip Talks podcast, a series of discussions about current legal issues hosted by Hugill and Ip solicitors. We are a young, independent law firm, but with decades of experience providing bespoke legal advice and exceptional client service to individuals, families, entrepreneurs, and businesses, both in Hong Kong and internationally. For today's episode, I'm here with Adam Hugill, and we're going to be discussing Hong Kong employment law issues. So, first question, Mr. Hugill. Hong Kong prides itself on being a very pro-business jurisdiction, but how does this apply to employment laws?
That's correct. Hong Kong is very pro-employer in the way that it sets up the laws, and they're not overly protective for employees. We have in place the Employment Ordinance, which has been around since the 1960s. The Employment Ordinance was written at a time when Hong Kong was a manufacturing hub, and a lot of the rules in the ordinance were drafted in such a way to protect employees in that environment. It has been updated many times, but it's not been fully overhauled in such a way that it makes it a very coherent piece of legislation for modern Hong Kong, especially with the financial services and the public sector. Hong Kong also has in place other laws to protect employees, the most notable being the Minimum Wage Ordinance, the Employees' Compensation Ordinance, and a series of anti-discrimination ordinances that protect against discrimination in the workplace. The Data Privacy Ordinance as well is also incredibly important in an employment context. Alongside the Employment Ordinance and the statutory protections, obviously there's then the employment contract as well, which tends to be the core document that most people go to when looking for their rights and obligations as an employee.
Okay, interesting. So you touched on the Employment Ordinance. Does that provide protection for all employees working in Hong Kong?
Yes and no. The Employment Ordinance differentiates between employees on the basis of continuous employees and non-continuous employees. And it's a slightly strange terminology that's used. But in a nutshell, a non-continuous employee is akin to being a part-time employee. And so the threshold is that you work for more than 18 hours per week over a 4-week period. If you meet that threshold, then you're a continuous employee, and all of the Employment Ordinance protections and rights will apply to you. If you don't meet that threshold, then you're a non-continuous employee, and the vast majority of the Employment Ordinance won't apply to you. So you won't receive protections in terms of minimum notice periods, paid annual leave, paid maternity leave, and things like that.
Very interesting. So you mentioned just a moment ago that the contract is king. That's probably a phrase that many people have heard of. But does everyone need to have an employment contract?
An employment contract isn't a legal requirement, and so you can hire employees without having an employment contract in place, but certainly it would be advisable to have a contract. An employee is entitled to receive in writing very core employment terms, and so if an employee requests, you have to provide them with a written notice of their wages, when their wages will be paid, which is usually monthly, and what their notice period is. But other than that, there isn't a strict requirement to put an employment contract in place, but it's certainly advisable in pretty much every case.
Interesting. That's good advice. So in addition to what you just mentioned, what other key terms or provisions would you advise be included in the employment contract?
The first term that most employers look for would be a probation period. Without a probation period clause in the contract, the employee isn't subject to probation. So you'd include probation, and there are a few rules that govern probation in Hong Kong. The first one that most employees and employers overlook is that the mere mention of an employment period in a contract means that during the first month of employment, either side can terminate the contract without giving any notice at all. And so it doesn't matter if the contract includes a different notice period, the law actually overrides that. After the first month of probation, it's usually 7 days' notice to terminate the contract, and then once probation's been passed, the full notice provision, which is in most cases 1 month for senior executives, maybe 3 months. For very senior executives, it's not unheard of for people to have 6 or even 12 months' notice in the contract. The other key terms in the contract, which are intended to protect the employer, would be terms relating to confidentiality and, most importantly, post-termination restrictions to prevent the employee from being able to substantially damage your business after they've left employment. Another term that is often overlooked, but it's very important for employment contracts, is a garden leave provision, which entitles you to ask your employees to remain away from work during the notice period. If you don't have a garden leave clause in the contract, then arguably you can't require employees not to work for you.
Very interesting. So to follow up with something you've mentioned previously, we've discussed the Employment Ordinance. We've discussed some of the key provisions and terms that should be included in an employment contract. But what about for international clients? Hong Kong is a very international city. There are lots of expats working in the territory. So how do international clients adapt to Hong Kong employment law?
Ultimately, Hong Kong law and employment law is based on UK law. And so if you're coming from a common law jurisdiction which has UK law as its core, so UK obviously, but maybe Singapore, Australia and the like, then Hong Kong law is pretty understandable for most employers. And most employers will find that the terms and policies that they have in place in their home jurisdiction would equally apply in Hong Kong. And so it's very easy to adapt and to transition. For employers coming from other jurisdictions, or the European jurisdictions, for example, America, sometimes the laws in Hong Kong are seen as pretty confusing. Most people accept that hiring and firing is very easy to do, but all of the things that relate to governing an employee in the middle, such as managing sick leave, maternity leave, annual leaves and the like, is actually very confusing, and it's a lot for clients to get their head around.
So we discussed that a large part of the Hong Kong Employment Ordinance deals with various types of leave, but what specifically is covered under the ordinance?
Okay, the ordinance covers annual leave, holiday leave. The difference is annual leave is what most people would consider to be vacation, and holiday leave is what we call statutory holidays or maybe public holidays, bank holidays. There's also sickness absence for employees who are ill. There's a separate system entirely for employees who've hurt themselves whilst in the workplace. And then there's maternity leave, paternity leave, which has been relatively recently introduced to Hong Kong law. And there's also a requirement in Hong Kong that at least 1 day in every 7 must be a statutory rest day. The difficulty for employers is that the law is very prescriptive in how each of these leaves are dealt with and how the rights are provided to the employee. And it's very difficult for most organisations to be able to grant this protection whilst following the strict letter of the Employment Ordinance.
So you're saying that the ordinance is very restrictive, but can you give some examples that employers should be aware of?
Okay. Holiday leave. It should be very straightforward in that it's a day off public holiday. But in Hong Kong, there's 2 systems. There's a statutory holiday leave system and a general holiday leave system. Statutory holidays cover 12 key holidays in Hong Kong, so New Year, Chinese New Year, Christmas Day, and the like. But in addition, there's also general holidays, which includes all of the statutory holidays plus 5 other days. And so the 3 days of Easter are a general holiday and not a statutory holiday. And looking at the strict wording of the law, different rights are provided for different types of holidays. And so, for example, statutory holiday is usually paid. A general holiday doesn't have to be paid. If somebody is required to work on a statutory holiday, then they must be given a day off in lieu. If somebody's required to work on a general holiday, which isn't a statutory holiday, then they don't have to be given a day off in lieu. And so there are a series of sort of complications and contradictions just in the system itself.
Yeah, that sounds quite confusing even to lawyers. So going back to something you mentioned earlier, you referred to maternity and paternity leave. So what are employees specifically entitled to?
Okay. Maternity leave has been provided for in Hong Kong for decades. And essentially, women are allowed to take up to 10 weeks maternity leave, which on an international standard is a relatively short amount of time. It's actually even shorter when you take into consideration that maternity leave usually starts 2 to 4 weeks before the date of birth. If you can't agree with your employer on your maternity leave start date, then it starts 4 weeks before you're due to give birth. And so post-birth, you're only entitled to a further 6 weeks of maternity absence, which for most people often isn't enough, and employers would grant ex gratia or additional leave to really extend that time. Paternity leave, as I said before, is reasonably new to Hong Kong. It's recently been increased from 3 days leave to 5 days leave. And that doesn't need to be taken in one block. That could be taken in individual days both before and after your birth of your child.
Okay. Well, it's good to hear that it just seems that at least paternity leave is on the rise and becoming more common as it is in many other Western jurisdictions as well. But for the actual leave days, is maternity and paternity leave paid leave?
For the most part, yes. There are qualifying criteria. So you have to be a continuous employee, which essentially means a full-time employee or an employee that works more than 18 hours per week. You also need to have had at least 40 weeks of service before the date you're due to give birth. In very broad terms, that generally means that when you started your employment, you weren't pregnant, and then you fell pregnant during your employment in order to get that qualifying criteria. An employee that starts a new job and goes on maternity leave 1 or 2 months into the job isn't entitled to receive paid maternity leave. And both for maternity leave and paternity leave, pay is at 4/5 of your wages, so 80% of your wages, which is the same as for statutory sick pay.
Okay, so it sounds like if you're on maternity or paternity leave, you'll get most of your wages, just not quite all. But you also mentioned sick leave just a moment ago. Let's turn our focus to that for a second. I assume there are complicated rules that govern sick leave and sick pay. Is that correct?
Yes, unfortunately, the law, again, is pretty convoluted when it comes to sick leave and sick pay. The way that it works is that during your first year of employment, you accrue 2 days every month, which essentially add up to being a paid sick leave bank. During your second year of employment or going forward, you accrue 4 days every month, which accrue towards a sick leave bank, and that caps out at 120 days. And so if you have sickness absence and you've accrued sufficient paid sickness days, then you're entitled to paid sickness absence. We've just mentioned that that's at 4/5 or 80% of wages. But there are further complications, one of which is, technically speaking, you have to be absent for sick leave for 4 days before you're entitled to any pay. And you have to provide a sick certificate to cover your absence as well.
All right. Honestly, all these rules and laws seem very complicated. How do employers proactively manage all of these?
Most employers will implement their own policies. One of the things that we need to check with the employers is that their policies meet at least the minimum requirements under law. As we've just discussed, the minimum requirements are usually reasonably low, and on an international basis, employers would have in place more beneficial rules and entitlements. And so, as we briefly mentioned, 10 weeks maternity leave, many employers, especially international employers, multinational companies, will offer more than that. They will offer additional paternity. Other practices that employers will also offer completely new benefits to employees which aren't covered by the Employment Ordinance. And so quite often we see bereavement leave. If a family member dies, they will be given an ex gratia period of time off. Marriage leave. And one of my more fun clients based in the UK offers what they call either a duvet day or a tequila day, which is a tequila day. So for employees who just don't want to come to work one day, maybe it's because of a hangover or not, they allow them a couple of days off each year where they don't need to make up an excuse or fake sick leave. They're allowed to just call in their duvet day or tequila day, which it isn't very prevalent across the board, but I think it's a nice benefit.
Interesting. Yes, you should try to get Tequila Day worked into your contract, it sounds like.
Yeah, and the most extreme that I've seen, I think it exists in Holland. If you want to conceive a baby, you can ask your employer to give you conception leave.
Conception leave. Wow, they have a leave for everything, it seems like. Okay, well, let's turn to the topic of termination. Hong Kong employment laws are widely regarded as being, quite pro-employer. Does this mean that terminating employees is easy?
In a nutshell, yes. Certainly compared to UK, European countries, Australia and the like, termination in Hong Kong is very straightforward. That being said, there are many pitfalls. And so as with most things, the starting point is the employment contract, and you would look to see what the notice period is in the employment contract. When looking at the notice period, the other thing to double check is that the contract's been signed. It's often overlooked, but if a contract hasn't been signed by both parties, then the notice period is 1 month, no matter what the contract actually says in it. And so for certain people, that might shorten the notice period. For others, it might lengthen it. When referring to notice periods, it has to be at least 7 days by law, but it could also be much longer than that. And also fixed-term contracts are relatively common. So somebody's locked in essentially for 12 months or 2 or 3 years, or has a termination date that's fixed at some point in the future.
Interesting. So you talked about how the termination process can work if there is an employment contract, but what if there isn't an employment contract? What then?
If there isn't an employment contract, then the law steps in and says that 1 month's notice is required.
Interesting. And how does that reflect the wrongful termination issue?
Wrongful termination is essentially being terminated in such a way that you've not been given either your statutory notice period or your contractual notice period. And so if somebody is terminated on short notice, or somebody resigns and doesn't want to work out their notice period, that's a wrongful termination. And that person would be entitled to sue their employer for the balance of the notice period that they did or didn't receive.
So what happens during the notice period?
The employer can do one of three things, and it's usually for the employer to make this decision. They can either require the employee to work out their notice period, so the person just comes to work and carries on performing their day-to-day job. Sometimes they get put on special duties or they get assigned different roles during their notice period. They could be put on what we call garden leave, which is they're still employed by the company, they're just not required to work. And so they still receive their wages, they still receive all of their full pay and benefits. They're just not required to perform work. And the reason for garden leave is if you have an employee who's in a key role, which could cause disruption to the company, and that employee is due to go and work for a competitor immediately after their termination, you probably want to keep that employee away from either your confidential documentation or away from your clients or from having sort of key strategic information relating to the business that they would then be able to take to their new employer. If you want to get rid of the employee immediately and the employee hasn't done anything wrong, but you're clearing them off your books, then you always have the right to make a payment in lieu of notice. Similarly, in Hong Kong, and I think it's the only jurisdiction in the world which allows this, an employee can also buy out their notice period. And so they can bring their contract to an immediate end by giving their employer a cash sum which is equal to whatever their notice period is.
Sounds like a nice, unique feature to Hong Kong for the employees. So to go back just a second, we touched on wrongful termination, but let's delve that a little bit deeper. So here in Hong Kong, are there any statutory protections for employees against being terminated?
Limited. And it's often very confusing for both employers and employees when they look at the ordinance and they see a section which is labelled unreasonable termination. And under unreasonable termination, it sets out 5 grounds on which you can reasonably terminate somebody. Redundancy, legality, misconduct, capability, or what we call some other substantial reason. In order to be protected, and I use this in a very loose way, from unreasonable termination, you need to have 2 years' service. The problem is if your employer has paid out your notice period or required you to work your notice period and paid out your notice and a few other benefits, then even if you've been unreasonably terminated, you don't have recourse against the employer. The situation where you do have recourse against an employer is if what you called unlawfully terminated. And I appreciate we're saying wrongfully terminated, unreasonably and unlawfully, but they all have slightly different meanings. An unlawful termination is if you've been dismissed whilst you're on paid sick leave, whilst you're on maternity leave, or after you've given notice that you are pregnant, or if you've suffered from a workplace injury which is still being investigated. In the case of sick leave and maternity leave, if you're on paid sick leave or you've given notice that you're pregnant, then the only time in which you can be terminated is if you're being dismissed for gross misconduct.
So it sounds like being terminated for gross misconduct is quite serious, as you can be terminated even if on sick leave or maternity leave under those grounds. But what does gross misconduct actually mean, and in what circumstances can you justify termination?
Okay. It's defined in the statute, but the reality is it's a very serious act of wrongdoing. I tend to advise clients that you can't really commit an act of gross misconduct by mistake. It usually involves something like deceit, fiddling expenses, stealing money, stealing from the employer, or very high level of negligence. If you've performed your duties incredibly badly and the employer suffers from that, whether it's financial loss or the like, or if you basically misbehave in the office. If you're an offensive person, if you commit acts of discrimination or harassment, then this would amount to gross misconduct, which would entitle you to be dismissed without any notice period. Essentially, you're told one day you're terminated, and that's it. You're entitled to your paid annual leave, your accrued untaken annual leave, but nothing more.
So are employees entitled to compensation if their employment is terminated?
In very limited circumstances, yes. And so you have your notice period, which we've talked about, which is either worked or can be paid. If you're terminated after 2 years of employment and the reason is redundancy, then you're entitled to a severance payment. The severance payment is 2/3 of your monthly wages, but that's subject to a cap of $22,500. And so what that means for people earning $22,500 or more is that you get $15,000 for each year of employment. If you've been employed for 5 or more years and you're terminated for some other reason, so not redundancy and not for gross misconduct, then you're entitled to what we call a long service payment, and that's calculated in exactly the same way. So $15,000 for each year that you've worked. The rub with statutory severance payment and long service payment is that the employer is entitled to set that off against the contributions that the employer has been making to your MPF account. And so, just to keep the numbers nice and easy, if you earn 30,000 Hong Kong dollars per month, your employer will be paying 1,500 Hong Kong dollars each month into your MPF account. And then when they terminate your employment, they can essentially take that back to cover the money that they've got to pay for statutory severance and statutory sick. In addition, and this is often overlooked, if an employee is entitled to receive an annual bonus, which is contractual, and so in Hong Kong, the most common type would be the Chinese New Year bonus, the 13-month bonus. Then if they've worked for more than 3 months of the bonus period, they're entitled to receive a pro rata payment of that bonus. What becomes very interesting is most large organizations and senior executives don't receive a contractual bonus. They receive discretionary bonuses. And there is a lot of dispute over whether a discretionary bonus is really a discretionary bonus or whether it's actually a contractual performance bonus. This becomes a real issue if the employee is being terminated and the employer decides that they don't want to offer a bonus payment or a pro rata bonus payment and maintains the argument that it's a discretionary sum, so we don't have to give it. The courts are prepared to look behind the word discretion and see what the reality is. And in most cases, in my experience, once you look behind the wording in the contract, there is a matrix, a formula, a scoring mechanism that goes into determining what the bonus is, and that then makes that bonus a contractual entitlement.
So while we're on the topic of termination, compensation, what about the scenario if an employee is unlawfully terminated? Are they then entitled to any further compensation than what you've already talked about?
Yes. In the case of unlawful termination, which is the limited grounds of being dismissed whilst on sick leave or maternity, or possibly even when you've suffered a workplace accident, you're entitled to claim a penalty sum of money. It's up to 150,000 Hong Kong dollars. But I've never seen the Labour Tribunal award that much. Quite often it's substantially less. Also, and again, this is a recent development, reinstatement and re-engagement is becoming an issue. Essentially, that means asking the tribunal to give you your job back. You can only ask for reinstatement and re-engagement in very limited circumstances, and you have to have been unlawfully dismissed and unreasonably dismissed. And whilst this remedy has been on the statute books for some time, previously the employer had to consent to you being re-engaged or reinstated. And I've never come across any employer that would want to voluntarily rehire one of the employees that they've sacked, especially one that's taken them through the Labour Tribunal. And so it was always a bit of a toothless remedy. But now that the law has changed, that the tribunal makes a determination as to whether anybody is reinstated or re-engaged, it is something which employees can meaningfully ask for.
Yeah, you mentioned labor tribunal a few times. Let's talk more about that. If an employee does have a grievance with their employer, what recourse do they have?
Okay. Well, everybody tries to resolve grievances informally, but say that doesn't work. Employees are entitled to bring claims in the Labour Tribunal. The Labour Tribunal is quite restrictive in the sort of claims that they will accept. The first criteria is you have to be an employee, and that isn't always the most straightforward question to answer. A lot of people are engaged as contractors. In the gig economy, whether people are employees or contractors can sometimes be very blurry. And so sometimes the first issue the tribunal has to deal with is, are you an employee or are you some other sort of worker? If you do satisfy the tribunal that you're an employee, then they will only look at claims which are for money or for reinstatement, as we've mentioned. And they're only claims that arise either under the Employment Ordinance or under your employment contract.
So what happens if an employee files a claim that doesn't fall within the jurisdiction of the Labor Tribunal?
The Labour Tribunal process to start, you've got to the individual has to make an appointment to meet with a tribunal officer, and the officer acts as something of a sort of a vetting procedure to try and ensure that only valid claims do progress to the tribunal. But say, for example, somebody misleads the officer or persuades the officer that they do have a case, then the matter will go to the presiding officer, and the defendant may have to run a defence of saying, well, before we take the case forward, we need to determine whether this person has a valid claim or not. And so there will be, if you like, a pre-decision before then the real claim is dealt with.
So in addition to what you just mentioned, how does the Labor Tribunal differ from the other courts here in Hong Kong?
The key feature of the Employment Tribunal is that lawyers are not permitted to represent the individuals. The employee must represent themselves and must appear at the tribunal and the hearings. And on the employer's side, an employee or a director of the company must also attend. And from my experience, it's the employers which are very nervous of attending the Labour Tribunal. In most cases, employers can put the matter in the hands of their lawyers, but HR representatives or directors of the company appearing in the tribunal is usually something that they're very keen to avoid.
I think that's very interesting to most people. So you said that the parties can't be represented by lawyers. Can the lawyers, at least show up and watch the proceedings?
Lawyers can act in the background, and quite often we're instructed to prepare the documents, prepare advice. Even though the matter is in the Labour Tribunal without lawyers, it can get quite complicated. As we've discussed, the law is pretty complex, and it's a difficult thing for individuals without legal assistance to pick their way through and understand. Lawyers can attend at the tribunal. It's a public forum. Anybody can sit in the gallery. But the presiding officer, who's the judge in the tribunal, tends to be pretty robust in ensuring that the lawyers don't participate in the proceedings. They're literally just there as spectators.
So they can watch, but they can't really interact.
And things can be paused. You have meetings outside the tribunal. There are often discussions and the like. But actually within the court, then lawyers have to remain silent, which is very frustrating for lawyers.
Yeah, I can imagine that must be difficult. Okay, so what can an employee expect when starting the tribunal process?
The first step is to meet with a tribunal officer and file your claim. I would tend to advise clients to prepare their statement of claim ahead of time and all of the documents cross-referenced ahead of time. And then that process can be shortened because you've got everything ready and your thoughts together with the documentation. Within 1 month of you filing the case, there will be what we call a first hearing, which is a hearing in the tribunal in front of a presiding officer. Prior to that hearing, usually about a week before, the defendant will have filed its defence. And from the defendant perspective, they usually would also have to attend at the tribunal, meet with an officer and file their defence. At the first hearing, the presiding officer will identify the strengths and weaknesses in their respective claims and defences, and often try and encourage the parties to negotiate or engage in some form of conciliation to settle. And if they don't do that, then directions will be issued for the case to move forward, which is usually exchanging documents, preparing witness statements and the like. And then there will be a series of follow-up hearings where the presiding officer is checking that the parties are doing what they needed to do in terms of progressing the case forward.
Okay. So it sounds like that there's at least the potential for the process to become, quite complicated. Is that right?
The labour tribunal process can become complicated. From start to finish, I would say that it could take 9 to 18 months, depending on how expediently the parties are sort of moving the case along and complying with the directions. If the case is very complicated, it contains a complex issue of law, or it contains a mix of claims which maybe don't necessarily fall within the labour tribunal, or it's for a very high sum of money, or a mixture of the above, then the tribunal, of its own motion, could send the case to the High Court or the District Court, and so it's dealt with through the formal court proceeding system. But similarly, an employee or an employer could ask the tribunal to transfer the case to either the High Court or the District Court, in which case then lawyers can become involved and the process will proceed in a very formal way.
So how often, in your experience, is a case transferred from the tribunal to either the district or the High Court?
The cases that we tend to handle for our clients tend to be more complex, and so it's not unusual for the claims to be moved to the High Court. And so I would say 50% or so of the cases that we deal with would be transferred. But that's because the claim is complex. If the claim is more straightforward and easy to settle, then obviously we would do that rather than pursuing the case.
Sure. Okay. All right. So let's say that you've filed your claim with the tribunal and you've won. What happens if the employer doesn't pay up?
Okay. The claim can be by the employer or the employee, and so the judgment could be against an employer or an employee. If an employee's not paid their wages or hasn't worked their notice period, you can sue employees in the labour tribunal as well. But yes, if you have a judgment in your favour, the rules are that must be paid within 14 days unless the tribunal has put some other provision in there for it to be paid in instalments and the like. If you are an employer and you don't pay a judgment within 14 days, quite often it will be picked up by the Labour Department's Criminal Investigation Bureau, who will then investigate why it's not been paid. And quite often they will bring criminal proceedings against the employer, possibly even against the directors of the employer, to, one, secure payment, but two, punish the company for not making payment. Conceivably, directors could go to prison for non-payment of tribunal awards, non-payment of wages.
Oh, so it sounds like it can be quite serious, if the person losing at the tribunal, doesn't comply with the payment order.
Yes, and something else that we can take advantage of in an employment law context is if a company doesn't have the money to pay or the company doesn't pay, in very limited circumstances, we can also go against the directors personally to secure payment from them.
Okay, well, let's switch gears a little bit. So we often hear that employees are the best asset of a business, but we know that they can also be a potential liability. So how does an employer protect themselves after an employee has left their employment?
Yes. Most organizations would view an employee who gives notice, especially an employee who's in a senior role or a strategic role, who you know or suspect is going to a competitor, as being, if you like, a danger to the company. And so they're usually very keen to try and manage that person during the notice period and protect their business after that person leaves. The way that you do this is via the employment contract. And in the employment contract, you would have a notice period, which means that you can attach a garden leave period to it. And so you can ask the employee to sit out of the business for the duration of their notice. You do have to pay them during that time and provide them with their usual benefits, but you keep control over that employee, so you can manage what they're doing, you can manage what information they have access to. Okay. Additionally, you would have in your contract confidentiality provisions, which most people view as being, if you like, boilerplate clauses, but they're actually very valuable. But the most valuable way of protecting your business post-termination is with what we call post-termination restrictions. And so that would be a series of clauses which say, for X amount of time after you're an employee, you shall not work for a competitor, or you shall not poach our clients, or you won't poach our staff, and things like that.
Yeah. We see these post-termination restrictions, these PTRs, in a lot of contracts. But, one question we get a lot is, are they really enforceable?
Most people look at them and say they're not worth the paper they're written on, but that would be a misguided view to take. Post-termination restrictions are enforceable, but they have to meet certain criteria. The way that the courts have looked at it is it's against public policy to prevent someone from being able to work for a competitor, but they will allow it in very limited circumstances. And the way that they phrase this is if it's reasonable to protect legitimate business interests. And so the way that the clause is generally drafted is you look at the duration of the clause. And so if somebody's restricted for 3 months post-termination, there's a fair chance that would be enforceable. If somebody's restricted for 2 years post-termination, in an employment context, that's usually too long. And so the whole clause would be struck down for being unreasonable. You would also look at the geography of it. And so if the clause is worldwide, then the employer is going to have to justify why they need a worldwide restriction against you, which is a very high burden. If it's just limited to Hong Kong, then it's more likely to be reasonable. And then overall, restrictive covenants are often poorly drafted. Either they've not been thought through, or somebody has sort of tinkered with the template and the precedent, which has sort of been updated over time. And so the restrictions don't make a lot of sense. And if it's a poorly drafted restriction, then it's very unlikely that the court would enforce that.
So what you're saying is if the restriction is badly written or just simply unreasonable, what's the remedy for that?
Okay, if you realize that you've put in place restrictions which aren't well put together, well crafted, or they're too wide, and the employee is still with you, then you can seek to impose new contract terms on them. The way that this is usually done is in connection with a promotion, but potentially in connection with pay rises and the like, that you can ask them to re-sign their contract with better terms, or you ask them to sign a standalone document. If the person's no longer in your employment and you think that they're a risk, you could try and impose restrictions on them in any termination document, so maybe a waiver and release agreement. But in most cases, an employee would want to be paid if you're going to impose restrictions on them. If you realize it's all too late and the employee's left and working for a competitor, and you look at the contract and you realize that it's not great, then the courts, in a very, very limited way, will do what they've creatively called a blue pencil test. And that means they will look at the restriction and they're prepared to usually delete only certain words that would then make the clause enforceable. And so if, for example, you have a restriction which says you shall not work in Hong Kong, Macau, Taiwan, and the court say, well, why would you need to protect Taiwan if you don't have a business there? The court may be prepared to delete the word Taiwan, which would then make the clause reasonable.
Okay, so it sounds like that in this limited scenario, the court might be able to step in and actually rewrite the contract. Is that right?
The court wouldn't go that far. They're prepared to delete, but they're not prepared to add. And so if you have a restriction which is for 12 months, say, and the court says that that's unreasonable, the court won't delete 12 and write in 3 or 6 months. They will just cross the whole contract out. And this is slightly different to the way it's done in other jurisdictions. You often see in Australia, for example, a clause drafted to say you shall be restricted for 12 months, you should be restricted for 6 months, you shall be restricted for 3 months. And then what they do in Australia is they essentially go to a court and say, which one of these do you think is reasonable? And they will apply that. Mm-hmm. If you did that in Hong Kong, the whole clause would be too ambiguous. Mm-hmm. Nobody would know the meaning of it. And so it would be struck down.
Okay.
And so the judges are very reluctant to rewrite or change the meaning of a restriction.
I see. Okay. Well, let's assume that the post-termination restriction is found to be valid. Does an employer have an obligation to pay the employee during that time that the employee is restricted?
If the restriction is reasonable, then there's no obligation to make a payment. That being said, many employers will compensate employees during the post-termination restriction period, usually based on base salary or a percentage of their base salary for the duration. What I tend to advise employers in such a circumstance is don't pay the employee their full wage each month of the restriction. What I would do is I would pay half their wage during months 1, 2, and 3, for example, and then pay the rest of it, the remaining 50%, as a lump sum at the end of the restricted period. And by doing that, you're encouraging the employee financially to really stand by the restriction. Otherwise, you find that people stay out of the market for 3 months, and then in month 4, they go, well, what's the risk, and may breach it because they know that the employer is not really going to try and enforce it against them if it's just got 1 or 2 months left to run.
Right. Okay. Well, let's talk about the scenario where an employee breaches a restriction. What happens then?
Okay. The classic scenario is you get a phone call from a client who says, I've just lost my top guy and he's gone and worked for a competitor. And what can we do about this? And so we would look at the contract. If there are restrictions in there preventing competition, we would write very quickly to both the former employee and the competitor to say, you're subject to post-termination restrictions, you're working for a competitor is unlawful, you must cease this immediately. And as I say, we copy that letter to the company as well. If that doesn't generate any results, then ultimately you need to go to court and seek an injunction, which is an order from the court that says that the employee must cease working for the competitor. And also you would join the other company into the proceedings, and so you'd get an order against them saying that they mustn't hire that person for a restricted period of time. If you're applying for an injunction, the advice is that you must act quickly. The court won't assist you if you delay in asking for a remedy. So if you spend more than 6 weeks deciding what to do whilst the person's working for a competitor, then almost certainly the court won't come to your aid with an injunction. The other way in which restrictions are enforced is by way of financial penalties. And so, especially in the financial services sector, you will see that people receive deferred consideration. So part of their bonus is essentially deferred and paid out over 3 years. And when their employment terminates, they may well still be entitled to that deferred tail of their bonus awards. And quite often that entitlement is connected with them complying with certain post-termination restrictions, whether it's non-competes or whether it's non-solicit or non-poaching of individuals. And so rather than going to court to seek an injunction against those employees, you end up either forfeiting or voiding their past consideration, which has been held back.
What about the scenario where there are no post-termination restrictions in the employment agreement? What protections does the employer have in those scenarios?
Okay, it's an unfortunate scenario for the employer. You do have limited protection under what we call the common law principle of confidentiality, which means that the employer shouldn't take confidential data from your organization and use it for the benefit of another organization. If they do that, then there's the opportunity to go to court and ask for what we call a springboard injunction. And what a springboard injunction seeks to do is if somebody's gained an unlawful advantage against you as a result of taking confidential data or breaching, say, fiduciary duties or obligations whilst they're an employee, the classic scenario is somebody gearing up to compete with you before they give notice, either on their own account or to work elsewhere. You can go and ask for what's called a springboard injunction, which is for a period of time to essentially null and void that unlawful advantage that the employee's got. And you can do that without there being restrictions in the contract. Actually, the law in Hong Kong only this year really clarified the principles of springboard injunctions and extended them to make them consistent with the United Kingdom law.
Okay. So with this springboard injunction, is there a time limit that an employer would have to apply for this springboard injunction?
Yes. Not a hard and fast time limit that's set in the rules, but if you don't take action very quickly, then the court won't assist you. All injunctions, whether it's based on a post-termination restriction or a springboard, are what the court called equitable remedies. And so it's not something that you have the right to, but something that a judge may extend to you to remedy a breach. And they always, the principle is that if you don't act quickly, then it would be wrong to ask for an equitable remedy. And so if you delay for more than 6 weeks from finding out that somebody has either misused your data or committed an unlawful act and they're taking advantage of that for a competitor, then you would be, if you like, informally time barred from bringing a case.
Be sure to catch our other episodes of the Hip Talks podcast by checking the Insights section of our website at www.hugillandip.com. And please send us your comments by writing to our email address hello@hugillandip.com. Also, please feel free to share this episode of the Hip Talks podcast with your friends, family, and associates. For the hearing impaired, you can find the notes and the transcript of this episode on our website. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.